Sidharth Luthra, you agree with that? Did the Supreme Court make the initial, in a sense, some would say, mistake by virtually saying, look, we believe that under Criminal Procedure Code, they've been in jail for 14 years. Now it's up to the state government. Should the Supreme Court have, in a way, had overriding powers, or at least sent out a stronger message that given the nature of the case, you've got to be more careful?
Rajiv, the issue is this. The Supreme Court relies upon the Constitution Bench decision in Sriharan's case, which lays down the parameters. It takes a certain view and remands it back to Gujarat. At this point, the field is open for Gujarat or any state to act in terms of its prevalent policy. Brinda has said we've not seen the 92 policy. Frankly, neither have I, though it's mentioned in the Supreme Court judgment. The 2014 Gujarat government policy takes a different view, but because the conviction took place prior to that, the prevalent policy will be in vogue. Should the victims have been heard? Yes, obviously, there's no doubt about it. But today, speaking at least for myself, the legal position as it stands is that the Supreme Court judgment remains untrammeled and unchallenged. Had there been a review, or had it been challenged, or had been questioned, things may have been different. But keeping in view the mandate of the Supreme Court 2022, it's a May 22 judgment, the Gujarat government was empowered to act in terms of its 92 policy, whatever it was, and the policy will have to see the light of the day. Of course, it is open to the victims to see whether what the policy is and whether there has been compliance with the policy. Because, as I said, in the 2014 policy, there is a restriction and exercise of power of remission in cases of rape and gang rape and murder. But we don't know the content of the 92 policy. I would assume that it did not exist at that point of time, and therefore, to deal with the other point you said, therefore the 2022 guidelines of the centre would not apply, keeping in view the mandate of the May 22 Supreme Court decision.
Okay, interesting, but the fact is, Aman, Lekhi, and I'll come to you, Vrinda, I know you're itching to get into it, but the fact is, just a minute, I'll come, Aman, Lekhi, the fact is the victim was not even, her view is not taken. When this decision is taken by a government committee, the victim's family at least has told us we were not even consulted. Now the gang rapists will go back to the same village where the victim lies. How have you ensured any form of justice? Today, Bilkis Bano could well turn around and say, I haven't got justice. The people who killed my daughter, who killed my family, who gang raped me are coming back to the village.
Let's break it down, Rajdeep, this is important. We are using the expression life imprisonment. Admittedly, life imprisonment in 45 is supposed to mean the duration of a person's life. But section 45 has to be read with another section, that is 433A, which says that after 14 years actual imprisonment, notwithstanding the sentence being of life imprisonment, a party is entitled to apply for remission, which attracts 432. Now, 432 goes to section 57, which helps compute the period of remission. When the matter comes to the Supreme Court, because the law permits remission to be considered, the application is considered by the government of Gujarat. You put this question whether the Supreme Court would override the Gujarat High Court judgment. Now, the Supreme Court can override because it's an appeal. And the reason why the Supreme Court overrode Gujarat High Court judgment, because Gujarat High Court had said that the court appropriate to deal with the matter was Bombay and not Gujarat. What the Supreme Court said was, because the offence is committed in Gujarat, the government which is competent to decide, that is the appropriate government, is the government of Gujarat. Now, the government of Gujarat decides in terms of the law which is laid down in 432. You pointed out that the victim is not heard, but insofar as the process is concerned, the process is governed by the procedure in 432, which sets out who is to be heard and how it is to be heard, and that goes with the remission policy.
So does the victim not have to be heard?
The remission policy in issue is the 1992 policy.
Sir, for our viewers, sir, our viewers will want to know,
pardon?
Under the law, victim doesn't have to be heard?
Yes, yes. As far as the remission is concerned, the hearing will entail the judge, the body constituted in terms of the committee under 432, and the facts of the case and the entitlement of the person be considered remission. What's very important is that while 432 entitles the person to apply, it doesn't vest in the person a right to be considered. Right. Now, the decision is of the government. There are two aspects to it. One, whether 432 would lie at all, because they're going on saying it's life imprisonment, mainly because it's life imprisonment, because it's not a special category of life imprisonment, which has come later. This is very significant because no one has talked about it. A special category of life imprisonment is where the imprisonment is without remission. Now that came in 2008 and it was affirmed in 2016. The judgment in Bilkis Bano in Bombay High Court came in 2017. The 2017 judgment, notwithstanding the Supreme Court having declared the law that the punishment can be life without remission, chose mainly to uphold the trial court judgment of life simpliciter. Now life imprisonment simpliciter is different from life imprisonment without remission. Had it been life imprisonment without remission, this order would have been illegal. But because it is life imprisonment simpliciter, remission is permissible. And because remission is permissible, in terms of 432, it has been considered.
Okay, so you're saying...
insofar as the entitlement for consideration is concerned, that is there.